We are going to be checking in with the very first status conference of Alex Murdaugh Part 2. Part 2.
I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. Do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be with SLED, and so I think that we are ready within reason, of course, to do this as expeditiously as possible. We do have another expert who testified from the FBI and things like that, but much of that is consent. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this, before the end of the year, like towards the end of the year. We're ready to go. About that. And so I'm not aware on the state side of any expert issues that provide for additional delay.
All right, Mr. Harperian, how about for the defense?
We have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need, the DNA.
Did he just say all of them are new?
We have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. To try it before the end of the year cannot be done for us to be adequately prepared.
She asked how many experts you had, and he's already filibustering about needing more time.
I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. And what we're comfortable with is late spring, early summer next year.
Okay.
Late spring, early summer 2027 is what he's saying.
Well, let me talk about this computer at the Department of Corrections. I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order.
That's a fair concern.
And some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case.
I think so too.
It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to?
That's a really reasonable balance. State grand juries, like federal grand juries, are always sealed and protected and are used in a very limited capacity for impeachment and are not to be distributed, disseminated, or anything like that. And it doesn't seem to be that onerous to say he can have everything except the grand jury transcripts, and the grand jury transcripts can be brought to him by attorneys. That's a very limited amount of information.
It's just hard to say what exactly our grand jury materials when a lot of the subpoenaed documents and information.
That's a fair
Your Honor,
that's a fair point.
what we'd like that laptop with the warden and corrections to have total access to it. It can be inspected by SWED to make sure it can't transmit an image, a message, it can be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. And these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a very,
Hoot, you're missing the point.
that's 100% of what we want him to look at. And we can certainly do that separately with hard copies. We have to go down there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing reversed about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to the murder. So it was much bigger than they say. I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas, and so all of this was in that ambit. And as well as Judge Newman issued a second, to my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. And so all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to, okay, is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that.
So there's more to this. The prison says no laptops, and Murdaugh lost his tablet privileges.
This is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member through the defense to him.
Lost his tablet privileges and contraband.
And so this is not a guy who was, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and made include the state and the evidence. I understand these issues very well. As a state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections are put in place, there's always ways around this, and SCDC has experience with that. And no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, it's too sensitive to have an inmate, despite what protections are put in place, have a laptop. Because, frankly, the reality is inmates are constantly and successfully violating whatever protections are put in place. Despite everyone's best efforts, you're doing a great job. It's just the nature of it.
Okay.
If we don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barber, or Ms. Fox have to go down there, 3 hours down, sit with them for 3 hours, 3 hours back, we're talking about at least the end of next year, not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a
Okay, this is a lot of hyperbole from Poot, for sure. But do you see the way that he's telling the court what it's going to be? If we don't get what we're looking for, it's going to take us until at least 2028 to do this trial.
Laptop that doesn't have any capability to communicate or copy. And we'll be happy to have SWED inspect it. And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Waters' job to legally prejudice the defendant, but this is beyond the pale.
I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law. I remember terabytes of discovery that I had to carry.
And this doesn't seem like terabytes of discovery, truly.
And I know that it can be cumbersome. And I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
He said 20,000.
It's very extensive. It's half a terabyte.
Half a terabyte.
Okay. I talked to the warden. He will not allow a laptop.
That answers that question.
And for safety reasons. He said he would, quote, make available a conference room. Council may bring their computer. They could have a law clerk come.
Right.
Or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. And no other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpootlian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop
Unfettered
computer
access
in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay?
Dr. Warden, we're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room as he would with us to look at it there. Does that make a difference?
Well, I'll ask him. But when I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally. I'll probably let you know before pretrial, but if he says no and it's for security reasons, then the answer is no. Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pretrial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
and
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now that I've been interfacing with. And they will be better able to answer specifically how long it will take. We've agreed to pay for it. And just background information.
I'm going to let you pay for it.
These murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on.
Oh, you want to do some IgG. Then the lab might have to make some additional SNPs to do some IgG testing. For those of you that are like, Emily, what are we talking about again? IgG is the investigative genetic genealogy that we saw and have talked about in the Koberger case, and that we have talked about with regard to the investigation into Nancy Guthrie. However, his statements about technology are not accurate. The IGG was around. It just wasn't used as frequently. And I don't know if IGG is going to help here, but maybe it will.
On the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year, in 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place.
Oh, so same lab. So they want to use the lab that was used in the Koberger case.
We're going to have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd asked Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they are they're certified. They work with law enforcement. I don't know that they worked specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send.
Correct. And they can work with the extract that SLED used when they did their STR analysis.
Yeah, but I don't know if they had enough of an STR analysis to run it through CODIS. You just said they didn't have enough and that's fine. And if they didn't have enough, then that's not fine. What they are trying to get to is that they want the court to issue a court order to connect SLED's DNA lab to Othram so that Othram can run the DNA that was located on the victims. I don't know if it's multiple points of DNA or just one, but they don't want it to go through SLED again. SLED's already done this analysis. They want SLED to give that information to Othram, which if SLED was able to complete a profile, and it's unclear to me if they got a complete profile to do this, then they should just be able to transfer the data. That's not hard. They shouldn't need to transfer any material. So I'm curious, but there were times that there just wasn't enough. If there are complete sequences, that's just data that can be sent.
They can work with that out there. They told me, but.
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures. And once I'm made privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back before Your Honor. That's precisely what I put in my motion is let's talk to them, let the experts talk so that my experts can hear, what it is that they propose to do. And I'm happy to consider it.
And I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alex Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential, and that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be
nothing
innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial. Let me move on to the motion for change of venue. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions and then I will decide.
Oh, well, that's interesting that the court may allow them to agree to a change of venue.
Yes, Your Honor. Of course, without taking a specific position right now,
Right.
Mr. Harpootlian this morning that, we can kick some things around. And like you just said, if we agree, great. If we don't, then of course we'll decide.
That's right. Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's you.
Picking a jury when you are bumping up on when people are going to be traveling a lot becomes exceedingly more difficult. So she is thinking of juror complications and is trying to navigate complications for the jurors, not as much for the attorneys.
So I'm thinking April 5th. I know that we'll have a new attorney general coming in. Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well.
Tell all y'all.
When I set a trial date, I don't do continuances.
Period.
I don't do it. Better be a really good reason.
Okay. This court is like, when I set a trial date, y'all are going to trial on that date. I'm giving you a heads up. I don't do continuances.
Better be a really good reason. So, how does April the 5th sound, Mr. Waters?
Yes, ma'am. So we'll be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or...
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
Alex Murdaugh was back in court for his very first status conference on his murder retrial. After the Supreme Court overturned his case, that case goes back to pretrial status, and the court set a tentative trial date for April 5th, 2027. The reason I say tentative is because the court asked for more information about what the defense wants to do with DNA testing and how long that will take. And the court expects the defense to have that information for her before or at the next pretrial hearing on August 14th, 2026. They will be back in court. This judge is the judge assigned for all purposes. We know that During this hearing, they discussed motions the defense has filed that we will be covering. They have filed a motion for change of venue. They have filed a motion because they want to do IgG DNA analysis and actually brought up in court the Koberger case and want the same lab to evaluate DNA or a DNA profile that was under Maggie Murdaugh's thumbnail. And so the court was asking them, how long will this IgG DNA process take? And is there enough of a profile to even do the IgG analysis? So the defense needs to bring those answers to the court on August 14th. And then the court said, if the trial date needs to move a little bit, that's fine. But right now it is set for April 5th, 2027. And the court said very clearly to the lawyers, I don't do continuances. What court they're going to go forward in is up in the air, because the court did let the attorneys know if they can agree on a change of venue, that the court would be amenable to that. And if they can't agree on a change of venue, or the change of venue is going to be objected to by the state, we don't know if it will be or not yet, that the court would then decide what happens with it. But if this case changes venue, this judge will stay with the case. So no matter where it's tried, this judge is going with it. This judge normally sits in Lexington County, but if this goes back to Colleton County or to another county in South Carolina, this judge and everybody else goes with it. And then it becomes a traveling circus. So we will be seeing the pretrial conferences in Lexington County, and then we will have to wait and see what happens with the defense motion for change of venue, the defense motion for DNA. There are some issues of protective orders. There is still an outstanding issue that Alex Murdaugh wants a laptop in prison. The prison has said no, but he wants to be able to go through his discovery. And I expect we will hear the defense bring that up more in the future because, well, Poot's already laying the groundwork for, but Your Honor, if we can't get him the files, there's so many files. It's like 20,000 pages of discovery. It's not a lot in a digital case, but we already saw the groundwork being laid. But if Your Honor, if he can't get all this information, we're not going to be prepared to go to trial in 2027. We're going to need till 2028. And the court has very clearly said that there would have to be very, very, very good reason for this case to get continued. Oh, and we also learned, though we had heard in the past, I don't think we had heard in court because this case hasn't been in court, that Alex Murdaugh did lose his tablet privileges in prison and had contraband of some sort at some point. So it's not as if Alex Murdaugh hadn't stayed out of trouble in custody either. And so that complicates things just a little bit. So we'll be back in court for Murdaugh August 14th, 2026. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.